This is Michael Popok. It's very dark. You can barely see me. It must be time for Legal AF After Dark. Judge Chutkan, she's back. I feel like this is like The Shining for Donald Trump, with Judge Chutkan coming through the door with an axe. Judge Chutkan, after waiting the appropriate statutory 30 days or so, has reasserted jurisdiction over the D.C. election interference case, and she's back with a vengeance. I don't mean that particularly. She's not biased, but she is chopping wood to get her work done. There's at least 4 or 5 motions to dismiss that Donald Trump filed back in October, over 9 months ago, that were put on ice while we awaited the United States Supreme Court decision about immunity. Well, we got that decision. Judge Chutkan's got work to do. She's clearing out the brush, and she's busy denying motions that Donald Trump filed back in October. And we talk about the upcoming status conference that she set for the next 2 weeks, in which she wants the lawyers on both sides to tell her how to get that D.C. election interference case back on track. We talk about it all on Legal AF, the podcast. One place, the MeidasTouch Network. And here we are.
Michael Popok, why don't we just get started, though, with Judge Chutkan, what she did over this weekend, right? Earlier today, she issued an order moving things along. We know that Judge Chutkan moves quickly, and Judge Chutkan was waiting for this opportunity. And here she says how the court now has jurisdiction over this case. She sets a status conference in this matter for August 16th. She denies Donald Trump's motion to dismiss on statutory grounds. She requests by August 9th the parties file a brief on the next steps. And so there will be a hearing in the next 2 weeks or so. The parties will submit a brief very soon as well, where that case is going to move along, and I think it's going to move along very, very quickly. I would not be surprised, although I've had this debate with Harry Litman. Harry Litman thinks that there won't be an evidentiary hearing that takes place before the election. I think there could be an evidentiary hearing that takes place before the election on the issues of absolute immunity. The Supreme Court said that Donald Trump, or presidents in general, former presidents while they were in office, get absolute immunity for core constitutional functions, for official acts for which there should be a strong presumption. The Supreme Court says that what you do in the White House is an official act, but it can be rebutted, a rebuttable presumption. And the Supreme Court said that there is an evidentiary exclusion rule, that evidence needs to be excluded at a trial from a jury if it involves official acts or core constitutional functions. So look, Donald Trump has filed a motion to vacate or remove the verdict in the Manhattan criminal case where he was convicted, citing the evidentiary exclusion portion of the Supreme Court's ruling, saying that there were witnesses who testified about things that took place when Donald Trump was in the White House, and as a result, the whole verdict should be excluded. The district attorney's office came back and said, "Judge, you've heard all of this evidence now, though, and we don't need to do an evidentiary hearing in the Manhattan district attorney case because there was a trial. These are not official acts." The presumption has been rebutted that this was done solely for Donald Trump's personal and pecuniary gain, even while he was in office itself. And to the extent anything else came in, it's harmless error, but the verdict should stand. So the question is, and I'll serve it back to you, Michael Popok, is number one, are you surprised Judge Chutkan moving so quickly? And two, do you think that there will be, though, this evidentiary hearing where Judge Chutkan will say, "Jack Smith, put on your evidence. Let's hear from you about all of the witnesses that you want to call to show that this is not core constitutional functions and not official acts. Donald Trump, put on your evidence. Are you going to testify?" "No, Your Honor, I'm going to plead the fifth." That's my Donald Trump plead the fifth voice. And what I think Jack Smith makes his argument on is essentially Blasingame interposed into this context of criminal cases, right? Blasingame, in the civil context of absolute immunity, said that, look, Trump's conduct involved campaigning on January 6th. It involved his attempt to overthrow a free and fair election. Donald Trump's lawsuits were filed not as Donald Trump in an official capacity, but Donald Trump running for office in 2020. So use the Blasingame, this was campaigning line of argumentation. Take that, put that front and center in an evidentiary hearing before Judge Tanya Chutkan. Michael Popok, call in Mark Meadows, right? Call in people like that. Call in the vice president. Establish that this was campaigning. Boom, and you make this you get a powerful mini trial too before the election. What say you?
Well, in the Littman v. Meiselas case, I have a feeling I'm going to side closer to Meiselas than Littman, but let me give you my, I think, and you and I usually see eye to eye on procedural things, but let me do it this way. I'll back into it, but I'll certainly answer the question. We are watching, as we've always said, a seasoned trial judge who'd been a seasoned trial lawyer handling things soberly in her courtroom. This is why we get very quickly, the prediction wasn't that hard, that she had 27 or 30 days from when the mandate from the July 1 immunity decision came out to reconvene the case after the D.C. Court of Appeals gave her a further mandate. I said it was going to be August 2nd, recognizing that she had already announced she was on vacation on August 5th, which is why she issued the order before the vacation and set a status conference for after the vacation. And while she was at it, there's about 4 different motions on the docket at various times that were filed that were all, a pin was stuck in all of them, and they were put on ice while the immunity decision was being worked its way through the trial judge and then the D.C. Court of Appeals first level appeal and then the Supreme Court. And that took like a year. So there was things on the docket since like October that she just ruled on against Donald Trump without prejudice. We'll explain that. We'll do a little Patreon breakout session here for teaching the law. So she went through and she said, what can I decide on like right now that I can just, that impacts, also interfaces with my ultimate decision that I've been charged with, or ultimate requirement that I map onto the indictment as it exists, the immunity decision, and then do like a waterfall, run it through the immunity decision and see what survives. What overt acts that are in the immunity, the indictment, and what counts. There's 4 counts and 1 defendant, Donald Trump. 2 for obstruction of an official proceeding, and 2 related to defrauding the United States, which has to do with the fake elector scheme and other things about the failure to transition power and the clinging to power, right? Interfering with the peaceful transition. So she's been charged by the Supreme Court, her bosses, to do 2 things. Look at the indictment and see if anything survives in it under what you've outlined in when you open the piece about is there anything that's absolute immunity, core constitutional function of the president that's been alleged as part of the indictment? Is there anything that is rebuttable immunity, meaning it's the Blasingame, official conduct stretched to its outer boundaries, president wearing the president hat for any of these things, yet it's rebuttable. The prosecutors can rebut that presumption of immunity, although the Supreme Court didn't really tell them how. And then lastly, things that fall into that little small bucket that they left over, which is unofficial / private conduct that enjoys no immunity. And she's got to go sort all this through. And that is that evidentiary hearing that you're projecting that you think will happen. And I sort of agree with you. I'll talk about the briefing that would lead to that in a minute. So she's got to do all that. And then in a footnote, they said, oh, while you're at it, like you don't have enough to do. Why don't you also figure out if 2 of those counts survive? Because there was a companion decision a week before in which they got rid of obstruction of an official proceeding applied to most, if not all, Jan 6th insurrectionists because they didn't get their grubby little hands on the certificates, the actual counting of the certificates. And for the judges, they were like, well, you didn't actually touch the evidence, so or rip up the documents, so you can't be charged with those crimes. But they not buried. On page 7 or 8 of the decision was a little thing helpfully included, I'm sure, by Judge Sotomayor, that if you use false evidence, to obstruct an official proceeding, then you can be charged with that crime. And what's the false evidence? It's the false elector certificates. It was obviously that is what's going to be argued, and I think that's what's ultimately going to have Judge Chutkan decide to have it survive. That's what she's got to do. Now let's talk about how she does it, the logistics of it, which is what you talked about. She's asking the parties on August the 9th, a week from, give or take from today, to propose to her briefing schedules and how to get these immunity issues back on track. Now, Jack Smith could, but I doubt he will, decide that he's going to re-indict Donald Trump and get rid of this indictment and start all over again. I don't see him doing that. I don't think he has to. I think he knew about the immunity possibility, the immunity decision going awry for him. Super smart, thought ahead, and has a way. I'm sure he already has the arguments and had them ready at the time he got the indictment, about how he was going to have that indictment survive any type of bad decision by the United States Supreme Court, which he ultimately got. So he's going to stand on that indictment, and he's going to point out to her in his briefing. They're going to brief this. We know from past experience, Donald Trump is going to ask for a briefing schedule into 2026, at least 2025. Certainly over the election, the inauguration. He doesn't want to deal with this. And Jack Smith's going to say, August. August is a nice time to complete briefing. Why don't we just complete all the briefing in August? And I think the judge is going to be like, well, August is a little tight. How about just after Labor Day? How about everybody gets their full briefing in and we time it out to conclude the week after Labor Day? It's something like that. And then she'll decide the oral argument / evidentiary hearing that she thinks she needs. She could go one of two ways. She could say, I don't need an evidentiary hearing. I'm just looking at the four corners of the indictment. I'm looking at the briefing that's been provided to us and my own guidance, my own research, and I'm going to say which is in and which is out and what survives and what doesn't survive. And I don't need to hear about I'm not going to put the government to their proof. However, she could also say, and this is where you come in, I want a full evidentiary hearing on this. I need to make a record. The Supreme Court's up my backside. They've told me I didn't do it right the first time. They told me that I was remiss. This is my version, the artist rendering of Judge Chutkan. I was remiss in not handling this at the outset and not putting the government to their proof. And now I'm going to do it. And maybe I'm going to overdo it. Belt and suspenders. If she's going to be conservative, she's going to go the evidentiary hearing route after briefing. Let's assume the briefing is what I said, September. She could do that evidentiary hearing in September as well, or maybe the beginning of October, but certainly back to you before the election. I think she thinks it's important. And most of the judges do, except the MAGA appointed ones, think it's important for the American people to that this not be in a black box, that this not be in a star chamber, that it be in public, and that they make a decision in their minds whether this guy's guilty or not, or whether the indictment's going to stand or not before the election. Even though it's not election interference, it's information that the public has a right to know before they make one of the most momentous decisions in our lifetime about whether it's going to be President Kamala Harris or a restoration of the Trump theocracy / dictatorship. And she cares about that. Most of the judges of the DC court system care about that issue. So I think she does get it up and running, like you said. So I'm with you on an evidentiary hearing after full briefing, all to be done before the November election, whether Donald Trump and his lawyers like it or not. Their constant bleeding, with a T, not a D, their constant complaining about election interference, and we're beyond that. There's no election interference. And now the fact that Donald Trump has to account for himself like any other defendant, civil or criminally in cases, is not a sign that judges are trying to interfere with his election, but they've got a job to do, and they've got cases on the docket that are not stayed, and there's things that have to be done. It's sorry if it happens to also land on a political calendar of when he wants to do a rally or a debate that he's apparently not going to do, or anything else. He's the nominee. We're about to have a Kamala Harris as our nominee. And now it's just a mad dash to make closing argument. There's no more primaries. It's just talking to the American people and voting. That's all that's left. So there's that argument that maybe had some resonance in his in his world about interference is sort of, for me, as I said earlier, I think it sort of has been taken away by the surge of Kamala Harris. Welcome back. There's an example of Legal AF, a podcast we've been doing for over 4 years at the intersection of law and politics. We don't blow smoke or sunshine. We just, as practicing lawyers, bring it to you the only way we know how. Unfiltered, uncensored, sometimes unhinged. But we give you the analysis that you've been looking for on the MeidasTouch Network and on Legal AF. Lawyers talking about things they know what they're talking about at the intersection of law and politics. How refreshing. Join us on Wednesdays and Saturdays at 8 p.m. Eastern Time. For the live YouTube version and on every major audio podcast platform of your choice. If you know about Legal AF, you're already a Legal AFer. We appreciate it. Take that clip, help us organically through word of mouth, grow our audience, send it to people in your life and ask them to join the Legal AF experience. If you don't know what I'm talking about, that was an example of Legal AF where we curate the top 4 or 5 stories at that intersection of law and politics and bring it to you right here on the MeidasTouch Network, and I invite you to join us. Until my next hot take, until my next Legal AF, this is Michael Popok reporting. Heary, Legal AF Law Breakdown is now in session. Go beyond the headlines and get a deep dive into the important legal concepts you need to know, and we discuss every day on Legal AF. Exclusive content you won't find anywhere else, all for the price of a couple of cups of coffee. Join us at patreon.com/legalaf. That's patreon.com/legalaf.